the minimums. Again, without the ability to reduce the punishment below the legal limit. The record also indicates that the defendant at the police station, as can be read in pages 104 to 113, I repeat, 104 to 113, before representatives of the public ministry, he accepted having committed the acts alleged and detailed the actions. Nonetheless, already once he was in a judicial facility, he questioned those statements, arguing that his rights were not guaranteed. As the interpreter had not been officially designated. Also, during the preliminary phase, he gave no statements whatsoever. Consequently, that statement does not satisfy the requirements. Consequently, that statement does not meet the required requirements to be considered a sincere confession. Consequently, the sentence cannot be lowered due to the sincere confession. 39. Nonetheless, the acknowledgement that he does make of his actions during the oral trial is conclusive in order to terminate the proceedings rapidly. Because that means a recognition of the laws that have been infringed and reveals the less requirement for punishment by signifying basically acceptance of responsibility of these actions. Must be then taken into account Plenary Agreement 5-2008 concerning the new ramifications of a speedy termination. In Fundament 23 on the principle of proportionality, acceptance in the trial must be evaluated against the criminal action committed. And this could benefit him with a punishment lower than what has been requested by the prosecution, applying a proportionality to the abstract punishment to be imposed. In accordance with the plenary agreement previously cited, and in accordance with the principle of proportionality and rationality. and thus must be consistent with the indications
a que se contrae los artículos 45 y 46 del Código Penal,
to which Articles 45 and 46 of the Penal Code refer,
conforme se ha glosado líneas precedentes.
as has been indicated previously.
Líneas precedentes.
Zoals hierboven vermeld werd.
40.
Nummer 40.
Por otro lado, atendiendo a las generales de ley,
On the other hand, considering the generalities of law which are in the record,
el procesado es extranjero
the
de
defendant
nacionalidad
is a
holandesa,
foreigner
Países
of
Bajos,
Dutch nationality from the Netherlands.
por lo que en aplicación del artículo
So
30 del
therefore, in
Código
application
Penal,
of Article 30 of the Penal Code,
se debe de disponer la expulsión del país
he must be expelled from the
una
country
vez cumplida la condena impuesta al procesado.
once his sentence is completed.
Séptimo, reparación civil.
Seventh, civil reparations.
Wat betreft de schadeloosstelling.
41.
41.
La realización de un delito no solo legitima la
The execution of a
imposición de una
crime
sanción penal,
It not only includes not only a penal execution,
Niet zeggen dat je dus alleen een dat je een straf krijgt, maar dat je ook
sino que puede dar lugar
it can
a una
also
obligación de
create
indemnizar por los daños producidos.
an obligation to indemnify for the damages caused.
En ese sentido, el delito en cuanto hecho lesivo
In that sense, the crime, as far as the damaging act,
constituye también un hecho
also
civilmente
constitutes
relevante
a
que autoriza
civilly
la
relevant action
que autoriza al agraviado
which
o afectado a
authorizes
exigir el
the injured
pago de
party
una
to
reparación
demand
civil.
payment of a civil
De
reparation.
familie van Stephany leiding kan geven om een schadeloosstelling aan te vragen.
Así, en materia penal, el
So,
objeto procesal es doble.
So in that case, the penal process is double. It is both penal as well as civil.
Debemos tener presente que la
We
reparación
must bear into
civil
account that civil
We
reparation
moeten in aanmerking nemen dat de schadeloosstelling
origina la obligación de reparar el daño civil
creates
causado
the obligation to repair the civil damage which has been caused.
handelingen die je gedaan hebt, moet je dat terugbetalen.
por un ilícito penal, causado por un ilícito penal,
Caused
Voor iets
by
wat
a
je
criminal
gedaan hebt in
action.
een strafrechtelijke geval.
debiendo entenderse por daño civil
It must then be understood that when we talk about civil damage,
Schadeloosstelling wil zeggen
como aquellos efectos negativos que derivan de la lesión
de negatieve
those
effecten die
negative
afkomstig zijn
effects
van,
de
that
un interés
arrive
protegido,
from a protected interest.
van iets dat beschermd is geworden.
los daños patrimoniales y extrapatrimoniales,
Property
En
damages
erfgoed
and
en de
non-property
en de
damages.
andere dingen met erfgoed te maken hebben.
es bajo este contexto
Is
que nuestro
In this
proceso penal
context, that our criminal
Is de
process
reden waarom onze strafprocedure
cumple con uno de sus roles primordiales
meets
met een
one
van
of
zijn
its primary
belangrijke,
roles,
que
punten,
viene a ser la protección de
which
la
is to
víctima
be the protection of the victim
om Stephany te beschermen
y aseguramiento de la reparación de los derechos afectados
and the
haar,
assurance of the
rechten die ze
reparation
heeft.
for the damages
por la
inflicted
comisión del delito,
through the
omdat je de daad
commission
begaan
of the
hebt.
crime.
en cuya virtud garantiza
In virtue of that,
la satisfacción
it
de
guarantees
intereses que el
the
Estado no
satisfaction
puede dejar
of
sin
the
protección.
interests which the
En
state
waardoor de
cannot
staat
leave
dus ook
unprotected.
deze handelingen in de staat haar moet beschermen tegen deze handelingen.
42.
Nummer
42.
42.
Para fijar la reparación civil
In order
se
to
tendrá
set
en
the civil
cuenta
reparation,
Om de waarde van de schadeloosstellingen vast te stellen,
la magnitud del daño ocasionado
the
al sujeto
magnitude
pasivo,
of the damage
moet
caused must be
gezien
considered.
worden, hoe erg de daad invloed heeft gehad op dit.
por lo que debe estimarse una indemnización
Therefore,
prudencial y
some
proporcional a favor
prudent
de este,
and proportionate indemnization must be estimated
conforme a lo previsto en el artículo 93
in
del
accordance with
Código
what is
Penal.
established in Article 93 of the Penal Code. which establishes that that includes restitution of the article, or in any case, the payment of its value and indemnification of the value of the articles removed. 43. As for the amount of civil reparation, the superior prosecutor requests that the defendant pay a civil reparation of 200,000 new soles, which he must pay to the closest relatives of the victim, considering his acceptance of these actions, as well as its legal consequences. That is to say that both the punishment as well as the civil reparation have been accepted. In that regard, stand up. In that regard, as far as civil reparation is concerned, the key principle that controls it is the disposable, is the principle of disposal. Since this amount is proportionate to the damage caused, and therefore the amount requested by the public ministry must be imposed. Besides, the civil part has not questioned the amount requested. Therefore, there is no alternative, no civil alternative proposed. And there being no document to back up the requested amount, no, this has not been explicitly detailed. Therefore, the tribunal assumes that range in which to set the amount. Seventh decision. 44. Consequently, because of all that has been stated, and in application of Articles 11, 12, 23, 28, 29, 30, 45, 46, 47, first paragraph, 92, 93, Article 108, subarticle 1st and 3rd, Article 185 of the Penal Code, in accordance with Article 280, 283, and 285 of the Code of Criminal Procedures, and Article 5th of Law 28,122. This tribunal of the Third Criminal Court for jail defendants, in accordance with the law, and administering justice in the name of the nation,
Uno,
determines 1.
condenando al acusado Joran Andreas
Condemning
Petrus van der
defendant
Sloot,
Jordan Andreas Petrus van der Sloot,
cuyas generales de ley obran en autos,
whose details are in the record,
como autor de los delitos contra la vida, el cuerpo y la salud,
as perpetrator of the crimes against the health, life, and body,
homicidio calificado
qualified homicide,
y contra el patrimonio
and
hurto
against the
simple
property of simple robbery,
en agravio de Stephany Tatiana Flores
the
Ramírez,
prejudice of Stephany Flores
y
Ramirez,
como tal
and as such,
le impusieron 28 años de pena privativa de libertad efectiva,
he is sentenced to 28 years of
que con el
incarceration,
descuento de carcelería que viene sufriendo desde el día 11 de junio del 2010,
considering the time he has been in prison since June 11th of 2010,
vencerá el 10 de
will
junio del año
expire
2038.
in June 10th of 2038
38.
of 2038. June 10th,
Vencerá el 10 de junio
2038.
del año
Op 10 juni van het jaar 2038 loopt je straf af.
2. Fijaron en la
So,
suma de 200
They have
200.000
set
nuevos
the amount
soles,
of 200,000 new soles,
Wordt 2000
el monto,
nieuwe soles.
el monto que por concepto de
which will
reparación
be the
civil
amount
Om aan de civiele
for civil reparations,
deberá pagar a los herederos legales
must
de la
be paid
agraviada
to the
Stephany
legal
Tatiana
heirs
Flores Ramírez.
of the victim, Stephany Flores Ramirez.
Stephany Flores Ramirez betalen. Nummer 3.
Tercero,
3.
ordenaron la expulsión del
ordered
país del sentenciado Joran Andreas Petrus
The
van der
expulsion
Sloot
from the country
Uitgestuurd.
of Joran van der
una vez
Sloot
cumplida la condena impuesta.
after completing the sentence that has been imposed upon him. Fourth,
Cuarto,
Nummer 4.
dispusieron
they
De
disposed
rechtbank heeft ook gezegd dat
continuar el respectivo juicio oral contra los procesados
to continue the oral trial
personen
against
John
the
Williams
defendants
Aparcana Pisconte,
John Williams Aparcana
John Williams
Piscante,
Piscana Pisconte,
John Osvaldo
Aparcana
Aparcana Pisconte,
John Osvaldo Piscante Pisconte,
y Carlos
and Carlos Alberto Uribe
en Carlos
Pretil.
Alberto Uribe.
Quinto,
Fourth,
Vijfde,
mandaron que consentida o ejecutoriada que sea la presente sentencia,
they have ordered that this sentence,
mandaron que consentida o ejecutoriada que sea la presente
that
sentencia,
the sentence agreed to or
de
written,
straf die wordt nu dus ingeschreven
registered,
se inscriba en los registros correspondientes,
shall
in de
be
registers,
annotated
escribiéndose
in the
los
records,
boletines y testimonios de condena,
and all the condemnatory bulletins shall be issued,
de registers.
archivándose definitivamente los autos
and
en
shall be,
cuanto a este extremo se refiere.
the record shall be filed as far as this is concerned.
Voor wat betreft deze zaak.
Firman
Wordt
Victoria,
This is-
ondertekend door
Victoria
This is
Montoya
signed
Peraldo,
by
presidenta
Victoria
y directora de
Montoya
debates,
Peralde,
Victoria
who is
Montoya Peraldo,
chairperson
de
and
voorzitter
director of the debates,
van de
Marta-
rechtbank.
Marta Vargas González,
Marta
juez
Vargas
superior,
González,
Marta
superior
Vargas
judge,
González,
y Pilar Carbonell Vilches, juez
and
superior.
Pilar Carbonell Vilches, superior judge.
Carbonell Vilches.
Vilches.
You have heard the sentence both in Spanish and Dutch.
Me reservo el derecho.
I reserve the right.
Ya consultamos.
We have already consulted. I have already consulted with my attorney.
Señor sentenciado, ¿cuál es su respuesta?
Defendant, what is your response?
Se reserva su derecho de
So
interponer el recurso que corresponde.
You reserve your right to
Señor
present
fiscal.
whatever briefing is required. The prosecutor. The
La
prosecution
parte civil lo puede hacer conforme a la ley.
agrees with the sentence, and the
Ha
civil part can do
concluido
it in
el
accordance
juicio
with the
oral
law.
con
This is the
respecto al
conclusion
sentenciado
of the civil process with regard to the defendant,
Joran
Joran Andreus Petrus
van der Sloot.
van der
Puede
Sloot.
usted retirarse de la sala.
You may leave the hall.